Hello, I'm Vanessa Antone, Senior Resource Counsel for NACDL, and I would like to welcome you all once again to Engage in Exchange. Engage in Exchange is a free member benefit for NACDL members, and a lot of you aren't NACDL members this time because we have allowed these episodes of Engage in Exchange as a sample to non-members. So please remember that these are, supported in part by the NACDL Foundation for Criminal Justice. And since they're a member benefit, please look into joining NACDL so you can continue to participate in the future. I think that's all of our announcements. Just remember, once we start, you will see our excellent speaker, Rene Valladares, and his PowerPoint. If you want to hide other people so you don't see little rectangles, you can toggle up there and click on hide non-video participants so you'll have the best view of everything we have going on here. So now, without further ado, I would like you to be able to kick this off, part 2 of the Busy Lawyer's Guide to Hearsay. Our speaker, Rene Valladares, has been here for the past 3 sessions, and we thank him for that. This has been an excellent session on evidence. He is the federal public defender for the District of Nevada. He's an adjunct instructor at the University of Nevada, Las Vegas, Boyd School of Law, and the UNLV Criminal Justice Department. He also lectures nationally on various criminal law and procedure topics, including the defense of conspiracy cases, the impact of culture in criminal cases, and search and seizure developments. Mr. Valladares serves on the Federal Defenders Performance Measurement Working Group and the Federal Defenders Death Penalty Working Group. He's co-editor of the first edition of the Practice Manual, Cultural Factors in Criminal Defense, which is now in its 4th edition. In addition to all of those accomplishments and many more, which we don't have time to discuss all of those today, he is also the author of The Defender's Guide to Federal Evidence, which is a trial practice handbook for criminal defense attorneys. We will give you a link to check that out and perhaps purchase it. That is the book on which this series is based. So without further ado, I will turn it over to you, Rene, and thank you once again for doing this wonderful series for us.
And thanks to you, Vanessa, for allowing me to do this. This has been an amazing experience to be with all of you here for this past month, doing this 4 lectures, this 4 presentations. So thanks to you, Vanessa, and thanks to each one of you that's viewing. I know that everybody in this discussion here is very busy. So I really appreciate you taking the time to go ahead and attend this discussion today. Today, what we're going to be covering is hearsay exceptions. In the first 2 presentations in this series, we covered character and impeachment based on character. Then last week we covered hearsay. We covered the first part of hearsay. In essence, what is the definition of hearsay. We covered also hearsay exclusions, and then today we're going to go ahead and cover hearsay exceptions. Now, what I'd like to go ahead and do is I'd like to go ahead and start with my PowerPoint here. I hope everybody can go ahead and view it. Allow me 1 second here, please. And the presentation today is like the other 3 prior presentations we had, is based on the book that Vanessa kindly mentioned, A Defender's Guide to Federal Evidence. And basically it follows the same format of the book. That is, we're going to be talking about the black letter law. We're going to go ahead and then talk about cases focusing very heavily on defense favorable cases that help us illustrate the different rules we're going to be covering today. And then we're going to go ahead and also in between, we're going to be covering practice tips and that sort of thing. All royalties for the book go to NACDO's Foundation for Criminal Justice and the amazing work that they do. And please jump in at any time. In addition, if you have any questions, don't hesitate to go ahead and email me my email link is Rene Valladares at federaldefender.org, fd.org. Don't hesitate to go ahead and email me if you have any questions about this presentation or about evidence issues in general. Before we start, you will see this icon, and that is Lizzie Borden being found not guilty at trial. And the reason, and you see it whenever we're talking about a case that is a defense favorable case. And the reason why I chose the Lizzie Borden case is not because, you know, of its macabre, you know, this origin or basis or whatever, but rather because this was a true triumph of defense strategy, of defense tactics, and despite all odds, the defense team made it work in this case through a lot of hard work and intense perseverance. So again, that's my email. Should you wish to reach me, and please do so. And I'm always more than happy to talk to anybody. And in addition to that, if you have any issues in your practice that involve Las Vegas, and my office in any way can help, please don't hesitate to go ahead and do so. So let's go ahead here and talk about our approach to hearsay. This is continuing the discussion from last week. And basically our approach is that, you know, we first start by looking at, is there a statement? Was the statement offered for the truth of the matter asserted? Is the statement excluded from the hearsay rules? Then we look at whether the statement falls under an exception, and then finally under the Confrontation Clause. Now today we will focus on box number 4. Does the statement fall under an exception? We're going to review quickly the first 3 boxes, and that is things that we covered last session. And we're going to also quickly talk about the Confrontation Clause. The Confrontation Clause obviously could be the subject of, you know, several different presentations. But we're going to cover it quickly, but really focusing on exceptions. So now, a very quick overview of what we covered last session. And of course, last session, we talked about hearsay definitions. For, you know, for hearsay, you have to have a declarant making an out-of-court statement that's offered for the truth of the matter asserted. We discussed the fact that not for the truth of the matter asserted encompasses a number of different types of statements. One could be course of investigation. We spent a lot of time talking about that. We talked about several examples about course of investigation. But in addition to that, you have for its effect on the hearer or reader, such things such as an entrapment defense, to show knowledge, or for impeachment. All those are things that, you know, come in as not for the truth of the matter asserted. We also talked about how this category is heavily exploited by prosecutors. In particular, last session, we talked about how the course of investigation exception or doctrine is heavily exploited by the government, heavily abused by prosecutors. We also talked about how it has to be balanced against Rule 403, its prejudicial impact. And we talked about how a statement by an officer that they proceeded on information received should almost always suffice. Unfortunately, as we discussed last session, oftentimes prosecutors try to go ahead and bring in a truckload of additional stuff, and oftentimes courts allow them to do it. So we need to be very much vigilant about this potential abuse by the government. We also talked about how you have hearsay exclusions that come under 2 big categories, one being declarant witnesses' prior statements, and then opposing party statements. As far as the first, declarant witnesses' prior statements, we talked about how you have prior inconsistent statements, prior consistent statements, and then also you have statements of identification. Again, you have declaring witnesses' prior statements, then opposing party statements. Let's quickly look at that. We discussed at our prior session how you have personal statements, adoptive statements, and so on. And we spent a lot of time talking about co-conspirator statements. We spent a lot of time talking about them because, again, this is an area that is heavily exploited by prosecutors, and where often courts, exercise little oversight, and oftentimes, much prejudicial material comes in. In this area, we talked about how statements have to be in furtherance of the conspiracy, and how oftentimes the government will try to bring in statements that are simple, that are just idle chatter. They're just idle conversation. Those do not count as being in furtherance. We talked about how casual conversation is not in furtherance and should not be coming in. So with that, now we're going to go ahead and turn to the meat of our topic today, and that is statements that the exceptions to the hearsay rule. And in essence, what we have is that there's about 23 exceptions that for whose availability of the declarant, the person that made the hearsay statement, availability of that declarant is immaterial. It doesn't matter whether they can testify or cannot testify. The statement, can come in regardless of the availability of the declarant. Now, there's 5 other exceptions where the declarant has to be unavailable. Now, altogether, there's almost 30. There's about 28. Now, obviously, there is no way in the world we can cover that in less than 2 hours. So what I've done is that I tried to go ahead and cover 10 of the first category, that is availability of declarant being immaterial, that is Rule 803, and 2 of the ones that deal with declarant being unavailable. Now, we can debate for hours whether I picked the right one, and you'd probably be thinking, geez, Rene, how come you didn't pick this one? Or how come you picked this other one here? And again, that's absolutely open for debate, and your critique is welcome and all that. But, I had to pick, and that's what I ended up picking. And even then, we're going to have to sift through a lot of this because there is so much. In fact, I like to cover almost 20 cases in which the defense favorable cases where we're going to be talking about, things that can help you in your practice, can help me in my practice, very specific cases that can be of great assistance. But, I had to really call down many cases from the book. All the cases that I'm discussing are contained in a defender's guide. And like I said, I had to end up really cutting back on many of the cases. I ended up reducing it to about 19, actually. Initially, I had like 30 something, but I had to really cut back. And even then, I'm going to be tight for time. Now, let's start then with hearsay exceptions where availability is immaterial. This is Federal Rule of Evidence 803. So by now we got hearsay. We went through our hearsay definition. The hearsay statements being used for the truth of the matter asserted. It doesn't fall under an exclusion like the ones we talked about last session. Here we're talking about hearsay, and the issue is, do they fall under an exception? So let's go ahead and get started here with present sense impression. This is a big one. This is a marquee one. And, to qualify here, in essence, you have to satisfy, or, typically the government has to satisfy 2 two elements. One, the statement has to be describing an event or condition. And the statement has to be made while or immediately after the declarant perceived the event. That temporal element is critical. It's a very critical temporal element. So the statement has to be near contemporaneous with the incident. This is in sharp contrast with the next rule that we're going to be talking about, excited utterances. In this case, the statement does not have to be startling. So Las Vegas Boulevard is right across the street from me, right in front of me. And Lori is crossing the street. There's nothing startling about that, but Lori is crossing the street. I'm describing an event. That's element number one as the event is happening. And I'm describing it again, while or immediately after element number two, that will go ahead and qualify. Let's look here at a nice example of this rule applying. This is a defense favorable case that really shows the importance of this temporal nature of this rule. In this case, what happened is that the defendant was convicted of interstate transportation of a stolen vehicle. Now, at trial, what happened here is that a trooper testified that he received information on a CB radio that a missing truck was found abandoned and that two white shirtless males were seen walking from the place where the truck had been abandoned, walking away from the place. Now, the district court allowed the statements into evidence, so the jury heard all this. This was very material to culpability. Based upon that, the jury found that indeed the defendant was guilty of interstate transportation of a stolen vehicle. Now, on appeal, the defendant argues that the district court erred in admitting the trooper's hearsay statement. And the Fifth Circuit noted that the distance and time lapses involved in the CB statements, in the statements that came through the Citizens Band radio, made it impossible to determine whether the declaration was made immediately following the observation or not. But the circuit noted that the chances were pretty slim that that was the case, that one could not tell whether in fact the statements were made in essence contemporaneously or close to contemporaneously, but it appeared that they were not. Because of that, the circuit ruled that 8031 was inapplicable because the timing element could not be established in that case. In addition to that, the Fifth Circuit noted that there was a significant possibility that the testimony that was conveyed by the trooper that this citizen had called in the Citizens Band radio had substantially impacted the jury. So the circuit reversed and remanded the conviction. Nice example again of a situation where the elements of the rule are not met. The time element, the contemporaneous element is not met or near contemporaneous. Now, let's look here at excited utterances. This is another one that we frequently see, another one that the government frequently tries to avail themselves of. And for this one to apply, what we need to have is a statement relating to a startling event. And it has to be made while the declarant is under the stress or excitement that startling event caused, okay? So here, different from the one that we just discussed, this one doesn't necessarily have a time element to it. Instead, is that if the individual still under the stress or excitement that the event caused. Let's look at a nice example of this applying in a defense favorable case here. This is the Mitchell case. Now, what happened here is that the defendant was convicted of conspiracy to commit robbery and use of a firearm during a crime of violence. Now, the government went ahead and introduced a note. It was a unanimous note, and anonymous, note, which stated that the man who robbed the store changed cars, and also the note included a description of the car and the license plate of the second car. Okay, so the police is in possession of this note. This note says that the individuals responsible for the robbery changed cars. The note describes the car, the second car, and gives the license plate. Well, the district court says, "Oh, this must qualify as an excited utterance. This must have been done under the stress of excitement." Comes in, and not surprisingly, the defendant gets convicted. Now, the defendant on appeal argues that the excited utterance exception did not apply, and the Third Circuit agrees. According to the circuit, the district court erred in admitting the note as an excited utterance because the record, quote, is devoid of circumstances indicating by a preponderance of the evidence that the author of the anonymous note actually saw the defendant change cars. Number one, that was the first thing that the circuit noted. And then number two, the circuit also noted that there was no indication from this note that the author of the note was under the stress of the excitement when they wrote the note. The Third Circuit vacated the defendant's conviction and remanded the case for a new trial. Again, very nice case if you are faced with this circumstance. Now, let's look at our third exception. And this one here is then existing mental, emotional condition, state of mind, basically. That's what we all know as the state of mind exception. So this is then existing mental, emotional, physical condition. So the elements are that the statement must describe the state of mind, that being motive, intent, plan, or emotional state of the individual or physical condition of the individual at the time made. But it does not include a statement of memory or belief. Now, if in fact the elements are unmet, such statement might be introduced to prove that a declarant acted in accordance with that intent. Now, you may remember all this from your old law school class, and you may remember the old case of mutual life insurance versus Hillman. Okay, and this case is a fascinating case, a fascinating read. Now, here what happened, as you may remember from law school, and for me that was a very long time ago, and is that in this case, what had happened is that Hillman's wife had gotten life insurance on her husband. And the wife claimed that Hillman had disappeared. Okay, Hillman is the guy to the left. Now, the insurance company said that no, that is not necessarily the case. That the body that was recovered, and this is a body was recovered by a creek, was not Hillman, that it was somebody else. And according to the insurance company, the body may have been the body of an individual by the name of Walters. That's the individual that's to the right. As you can see, there is some vague similarity there, but certainly that's debatable. Now, what happened here is that the insurance company offered letters written by Walters into evidence to show that, in fact, Walters was going to go with Hillman to this particular creek in question. And, the insurance company wanted those letters in question, to show that, in fact, the body may have been that of Walters. In the letters, are letters from Walters to his fiance. Walters was telling his fiance that he was planning on going with Hillman to this particular area, this area being an area where this creek was at. Now, so the defendant argued that the letters would show that Walters went to a creek with Hillman, and that the body could in fact be that of Walters as opposed to that of Hillman, like the plaintiff was claiming. Now, the district court excluded the letters, and then of course the Supreme Court eventually ended up hearing the case, and the Supreme Court ended up concluding that the letters were indeed could be introduced to show that Walters had the intention of going to a creek with Hillman, which made it more probable that in fact he ended up going, and that potentially, that could have been the body of Hillman. And the exception, of course, was that, that of state of mind, the intent of this fellow Walters. So that's where all this came from. It makes for interesting historical background, but let's look at some of the issues that come up with this rule. And for us, for our purposes, one of the main issues is that statements of memory or belief do not come in. So for instance, I'm scared is okay. That comes in as state of mind, but I'm scared because Joe Smith threatened me several days ago. That is not going to go ahead and be okay. Let's look at a good example of this, and this is the Demarcy case. Now, what happened here in Demarcy is that a jury convicted the defendant of attempted aggravated sexual abuse of a minor. Now, in the case here, the victim's mother testified about what her daughter, the victim, had told her on the night of the assault. Now, the trial court admitted the testimony, and the testimony basically described what happened when the girl came to her mom, and the girl came to her mom complaining about being assaulted by the defendant and that sort of thing. Now, on appeal, the Eighth Circuit noted that Rule 8033 does permit the admission of statements of the declarant's then existing state of mind, emotion, sensation, or physical condition. But it highlighted the fact that it does not include a statement of memory or belief. So let's look to see how this played out. In this case, the Eighth Circuit concluded that portions of the mother's testimony were based on the victim's statements related to her physical state. The victim was bleeding, and she said, "I'm bleeding because the defendant had assaulted her." The victim ended up also telling her mom a bunch of other stuff, and that is that she was sleeping, the defendant came in, the defendant woke her up, and the defendant wanted to see if the victim wanted to watch TV, and then the victim went to sleep again. The defendant woke her up again, the defendant pulled a mattress, and then, after all of that, the defendant assaulted her. The Eighth Circuit said that it was fine for the mother to testify that the victim did say that she was bleeding, that she had been assaulted, but that all the extraneous information that she provided was nothing but a statement of belief or memory, which was not included under the rule, and consequently the district court erred in allowing all that evidence in. So all the remainder of the mother's testimony did not did not have to do with issues dealing with her daughter's state of mind or physical state. Instead, it was just issues dealing with her daughter's memory, which were not permissible under the rule. Okay, now let's go ahead and look at statements for the purposes of medical diagnosis or treatment. And if you can guess who that person is in the image, I will send you a free copy of the book. I'll give you 2 minutes to figure it out. You can't look at it. You need to know from memory. We're going to go ahead and go honor code on this. But again, if you know who it is, great, email me. And the first that emails me gets a free book. But again, please don't look at it or anything like that. At any rate, the elements of the rule are that the statement must be made for medical diagnosis or treatment, and the statement must be one that would be reasonably relied upon by healthcare provider for treatment or diagnosis. Now, by the way, this is Dr. Rebecca Lee Crumpler. This is the first African-American woman to earn a medical degree in this country. Her story is absolutely, it's astonishing. And it's an inspiring story of determination and courage, things that, all of us as defense lawyers regularly need. And in reading her story, certainly it's been a great inspiration for me. Let's take a look at the scope of this rule. It is a big rule in that it allows a bunch of different, things to come in. So for instance, you have doctor, my knee hurts, that comes in. Nurse, my knee hurts. So it doesn't have to be a doctor, it can be a nurse, basically any healthcare provider. Doctor, my knee hurt yesterday. So statement of memory, unlike the prior rule we talked about, this comes in. Doctor, I was stung by a jellyfish while I was visiting Mary at the beach. That would go ahead and come in. And even Dr. Mary was stung by a jellyfish at the beach if I'm accompanying Mary. So all those statements would come in. This is a pretty broad rule in its scope. Nonetheless, there are important limitations to the rule from our standpoint, especially when the government is trying to capitalize on this rule, which the government will often, try to go ahead and do. Let's look at an example here, or rather, before looking at an example, let's look at, an issue that is critical for us, and that is that a statement that identifies the perpetrator usually should be excluded under this rule. So statements that assign fault or identify the perpetrator typically should be excluded should be excluded except for very rare circumstances. By the way, that's Bonnie and Clyde horseplaying in the picture there. Now, let's look at a nice example illustrating this rule here. And that's the Hearsay Case. This is, again, a good example that illustrates this principle that I just mentioned. Let's look at what happened here. A jury here convicted the defendant of aggravated sexual abuse, and the victim allegedly was the alleged victim was a foster daughter of the defendant's sister. Now, at trial, what happened is that the victim testified that she was assaulted by the defendant, and that after the assault, her boyfriend drove her to a local hospital where she was examined by a nurse, and then interviewed and treated by a doctor. The doctor testified, and the doctor, went ahead and repeated at length statements made by the victim, including statements dealing with the identity of the perpetrator. The doctor said that the victim identified the perpetrator as being the uncle in this case. And the victim, according to the doctor, said that the uncle, the defendant, was the one that had sexually assaulted her. The district court admitted the evidence over defense objections, and the doctor got to testify as to the identity of the perpetrator as per the victim and what the victim had told him. On appeal, the defendant argued that the district court erred in allowing the doctor to testify as to the identity of the perpetrator. And the Eighth Circuit agreed. The Eighth Circuit noted that statements made to a professional concerning treatment are usually admitted into evidence under 803.4. But that statements identifying the assailant are seldom, if ever, sufficiently related to diagnosis or treatment to be admissible. Statements identifying the assailant are admissible only, according to the court, if the identity of the abuser is relevant for treating the victim's emotional or psychological injuries. Here, the doctor's testimony was related to the statements about identity, had no clear relationship with diagnosis or treatment, and consequently, the Eighth Circuit held that much of the doctor's testimony was inadmissible under Rule 803.4, and the court also concluded that the error was not harmless, and because the error was not harmless, the Eighth Circuit ended up remanding for a new trial. The few circumstances where courts have concluded that a statement of identity may be relevant is when you have a minor child and you have, say, one of the parents is the abuser or that sort of thing. But again, those cases are very limited and should be the absolute exception to this. So again, issues that deal with identity or assigned fault should not be coming in under this rule here, under 803.4. Okay, now let's go ahead then and move on to our next rule, and that is 803.5. And once again, thank you for joining me today. I do know that everybody's busy, and I hope that this is of some degree of service. I find it that it's very helpful for me to go ahead and spend some time regularly going over the rules and remembering what are the points that are important and things where, you know, that are potential traps, as well as things that we need to be on the lookout for. So this is past recollection reported. Now, you know, first of all, for starters, obviously this is not refreshing recollection. You know, refreshing recollection is the witness is on the stand, the witness doesn't remember something, but, you know, the witness wrote something, typically the officer's report or whatever. The officer takes a look at that, it refreshes the recollection, or at least the officer says so, and then we move on. This is when, you know, the witness once has knowledge, but now has forgotten. The witness can't remember. And the record was made or adopted by the witness at a time when the matter was fresh in the witness's memory. Now, important to note that the record can be read to the jury, but does not come into evidence unless offered by the opposing party. So then let's look here at a nice example of this, defense favorable example, the Morning case. And all these cases are, you know, cases that are nice to have ready at a trial, just in case you need to go ahead and argue this issue. So what happened here? Well, the defendant was convicted at trial of mail fraud arising from a telemarketing scheme. Now, what happened here is that the government presented testimony from the defendant's cousin. The defendant was the owner of a business, and the cousin had worked at that business for about 6 months. Now, what the government tried to do is that the government tried to establish through her testimony that the defendant used the business, to cash money orders that were made out to insurance companies, but you would go ahead and cash them fraudulently. In the testimony, the cousin who had worked at a business said in her testimony in court, she said that she could no longer remember the particulars of her employment. So as a result, the government directed the cousin's attention to a statement she had made before. She had made this statement to an official, this is a Canadian official, in which she identified the defendant as the individual who routinely cashed money orders that were made out to different insurance companies. This was the subject of the fraud. The cousin, however, has said at trial that she didn't remember, I already mentioned that, and that she had suffered injuries since she had worked at this place. She had suffered head injuries in a car accident that, that impaired her memory. So, all this came in at trial, and the defendant was convicted. On appeal, the Third Circuit noted that the cousin's prior statement did not meet Rule 8035 because she neither adopted nor reviewed the statement prior to the memory loss. And again, those are elements of the Rule 8035, past recollection recorded. The witness once acknowledged, but forgot. That part seemed to be correct here, but she didn't make or adopted the record, and that's what essentially is in play here. So the Third Circuit noted that the cousin's prior statement did not meet the requirements because she neither adopted nor reviewed the statement prior to her memory loss. 8035, according to the court, requires that the witness either make the record herself, make the statement herself, or that reviewed it and adopted the statement at the time when it was fresh in her memory. And neither of the two occurred here. She didn't make the statement. This was made by a Canadian official, as I mentioned earlier. And second, she never reviewed it. She never adopted it. She never said, yes, this is correct. She never did that. So here, according to the circuit court, this recording was made by someone else, and the government failed to prove that, again, the cousin either, the witness either reviewed or adopted it in any way. So the district court erred in this case. Now, let's move to business records. Again, this is something that we see frequently, especially in fraud cases. We handle a lot of fraud cases here in my office, in my district, as you may imagine, being Las Vegas. So business records. Business records has a number of different elements. The record has to be made at or near the time, so you got a temporal requirement. The second requirement is that it has to be, the information has to be transmitted by a person with knowledge, made by or transmitted by a person with knowledge. Of course, the record has to be kept in the course of a regularly conducted business activity, and it is the practice of the business to keep such records. In addition to that, there's got to be we have to have the testimony of a custodian or other qualified witness, or the record comes in through certification. And importantly, and this is something that we all need to, that we should always keep in mind, is that the opponent does not show that the source of the information or method of preparation indicates lack of trustworthiness. Something that we all need to keep in mind, because oftentimes these record-keeping systems do have many errors. Oftentimes, they are plagued with all kinds of circumstances that indicate lack of trustworthiness and that sort of thing. So something to keep in mind. A couple of things that are very important about the business record exception are that, of course, they cannot be prepared. The record cannot be prepared in anticipation of litigation. And then also, be on the lookout for hearsay within hearsay. So let's look at a couple of examples that are going to flesh out the business record exception here for us. One is the Williams case. This is a nice case here again. What happened here is that the jury found the defendant guilty of transporting in interstate commerce a stolen vehicle. This is a nice, simple example of the rule here. Now, the defendant was employed as a tractor truck driver and was contracted to drive a load of products. The defendant never delivered a load or for that matter, the trailer, okay? So, hence the charge in this case. Now, at trial, the government introduced business records made by the operator of a trailer maintenance facility. The operator of the trailer facility did not testify. And the records were introduced for the purposes of showing the fixed market value of the stolen record. That was the purpose of these records. Again, the person that made the records is not testifying. The government is trying to get in the records as business records. The government is successful before the district court at arguing that, and they're able to get the records. The records are important because, again, they show the fixed market value of the stolen trailer. Now, remember, this facility here, the one that whose records the government introduced, this is a trailer maintenance facility. Now, on appeal, the Fifth Circuit held that the statement of the trailer's value did not fall within the exception. This was not part of the regularly conducted business of this business. Essentially the business was a trailer maintenance facility, repairs, maintenance, and that kind of thing. They were not in the business of evaluating tractor trailers or anything like that. That was not their business. This is not something that they did as a regularly conducted activity for that particular business. So, the circuit in this case, said that here the record was not part of the regularly conducted business activity. Instead, it was created for the purposes of trial. Because of that, it stripped the record of its trustworthiness that's required under the rule, and the rule did not apply in this case. The court noted that the district court's admission was certainly prejudicial to the defendant, and consequently, the circuit court reversed and remanded for a new trial. Nice case to have there, again, with you, a trial if you think that something like this may be popping up. Now, let's look at another example, another case example that deals with the business records exception and the kind of things that can come up under this exception. Now, and this is one of the things where you see the government trying to engage in the type of typical shenanigans that they engage in. And this is by having an agent testify, pretending that the agent is, an expert in the record keeping of a particular business. You'll see how this plays out. So the defendant was convicted of various drug offenses in this case. Now, a detective for State Drug Task Force had received information from a company that one of its employees, the defendant in this case, was ordering hydrochloric acid, which using the company name without the company's permission. And this acid is used in the manufacturing of methamphetamine. That's why the authorities were obviously very keen on this order. Now, at trial, the district court says, "Oh yeah, this comes in," and allowed it, to come in. And again, what happened is that the government invoked the business record exception and introduced the records of the business. This is the business where this individual, the defendant, worked at. But the government introduces the record through through an agent. The agent, I guess, cursorily reviewed, how it was that the business kept records and stuff like that. And then all of a sudden, the agent is an expert on how that particular business keeps the records and all that. And that's the way the government played it out. In this case, again, not surprising, as the government engages frequently in those kind of antics. Now, so we're on appeal now, and on appeal, the defendant argues that the detective was not qualified to go ahead and get this admitted under Rule 8036 because he really didn't do any serious, significant, thorough job at examining the company's books, the company ledger sheets, or anything like that. He really didn't, know how is it that the accountant or the bookkeeper, kept the books. I mean, basically, he had, as I said, a very cursory, type understanding of how the records were produced in the case. And the circuit said that in this case, it was clear that the agent was not familiar with these records. There was really no evidence that the detective had any significant familiarity with how the company kept the records, and the records were inadmissible, and certainly the district court erred in allowing them. So, again, just be on the lookout for that. Now, let's go ahead and go into a close cousin of the business records, and that is public records. This is Rule 8038. And under this rule, records that set forth activities of a public office or matters observed in the course of that office's official duties come in under public records exceptions. And of course, just like with business records, they come in unless the opponent can show lack of trustworthiness. Now, let's look at some important issues for us as criminal defense lawyers and how public records are implicated. So first, let's start with the Margaret Piatto case. This is a great case here, and what happened here is that the defendant was convicted of being a removed alien found in the United States. Now, on appeal, the defendant argued that the district court erred in admitting under this rule, under 8038, the defendant's application for status as a permanent resident. So what had happened is at a trial, the district court allowed in this application for status as permanent resident. Now, the Ninth Circuit, noted that yes, indeed, this application concerns the activities of a government agency. So far, so good. and that these were, documents that had to do with observations of a government officer. Again, so far so good. But the problem here with the records is that a critical part of the records, and this is what the government wanted them, was because they contained hearsay statements by a civilian, not somebody, not an official, and where that individual said that the defendant, in fact, was born and was a citizen of Mexico. So this application for status permanent resident had this statement that contained this hearsay statement. As I said, the statement was allowed by the district court. On appeal, however, the Ninth Circuit says, that's not permissible. That document, while yes, it was a document that was prepared by and reflected the activities of a governmental agency, it did contain within it impermissible hearsay that should not have come in and that did not qualify under any other exception. So because of this double layer of hearsay, which required a separate hearsay exception that did not exist in this case, the Ninth Circuit held that the district court erred in admitting the application, and because that was material to the case in this particular case, the Ninth Circuit reversed the defendant's conviction and remanded the case for a new trial. Great case. Now, let's look at another critical issue within that exception. And again, just to make sure that we're on the same page, we're talking about 8038, public records. And let's look at the law enforcement exclusion. So, and again, this is one of the very, very few areas where the federal rules of evidence actually have something that is in our favor. Okay, I mentioned throughout the prior presentations that there's a couple of areas here and there where that happens. Typically, the rules favor the government, but here there is something that does benefit us, and we need to go ahead and use it. So that's 8038. 8038 bars the prosecution in a criminal case from introducing factual findings resulting from an investigation. Let's look at an example of that. Now, we can use it. Actually, we can certainly use it, but the government cannot. So let's look at the Orianna Blanco case. Another, great and very helpful case. So here, what happened is that in Orianna Blanco, and this is another Ninth Circuit case, the jury convicted the defendant of marriage fraud and making false statements on an immigration document. So the defendant, at trial had taken the stand, had testified that his marriage was not a sham and this and that, and testified as to, the living arrangements with his supposed wife. The government was saying that there was really no matrimonial bliss. There was really no matrimony there. It was all a sham and that sort of thing. The defendant was arguing that no, this was a legitimate marriage and there was nothing fraudulent about it. So the defendant, testifies, and the defendant testifies that the marriage was not a sham, that they did intend to live together, and so on and so forth. Now, the government, however, to show that the defendant was lying, introduced an INS record of sworn statement signed by the defendant. So the government tried to show that the defendant lied, and in doing that, they want to go ahead and have this document introduced to show that the defendant lied and to show ultimately that in fact the marriage was a sham and the defendant should be convicted. In the document, the defendant had made a series of statements about the marriage that were significantly at odds with his position at trial. Now, the district court allows the statement, and the defendant ends up being convicted. So on appeal, the defendant argues that the exhibit was improperly admitted under Rule 803A. Now, the Ninth Circuit Court of Appeals agrees and notes that in criminal cases, Rule 803A is limited to records of routine, non-adversarial matters in a non-adversarial setting, and that this rule does not apply to the observations, summaries, opinions of law enforcement personnel in a criminal case. So first, the court looks at the setting in which this statement had been made before, the statement that the government wanted to introduce and successfully introduced at the district court level. The circuit looks at that interview and notes that indeed that document was adversarial in nature, that the defendant had been put under oath. At this point, the authorities were suspicious of the defendant, suspicious of his marriage, and they put the defendant under, at that point, suspect under oath. If, according to the circuit, if after that questioning, the authorities would have been satisfied, then fine. But if not, certainly that's something that was going to be used against the defendant. And indeed, that ended up being the case. It ended up being used against the defendant at trial. So according to the circuit, the exhibit fell within the criminal case exception to Rule 803A. And the circuit concluded that the district court erred in allowing that document in. The court concluded that this error was not harmless, and the circuit reversed and remanded the case for a new trial. So again, nice illustration of how law enforcement documents cannot be used against the defendant under this rule. Now, let's go ahead and look at two rules, and these are the opposite of the two prior rules we talked about. We talked about business records, and we, also talked about public records, and this is the absence of both, and that is covered under Rules 7 and 10, or subsection 7 and 10, I should say, of 803. And that is, again, absence of a record. Now, so the idea basically is that the absence of an entry may prove non-occurrence. And again, unless the opponent can show trustworthiness. And again, this is something where we always have to take a look at. The government uses this kind of stuff all the time, and they show it to try to show failure to file a tax return, failure to obtain a firearms license, for a certificate of non-existence of immigration record, you name it. But oftentimes, all these records are they are literally garbage. They're not kept properly. They're shoddy. They're spotty, and all that. All those are things that we need to keep in mind, and to try to go ahead and make challenges to the government evidence based upon that. If, however, that does not work, there's other ways we can go ahead and try to attack them. And this case here is a great example of a way that we can do just that. Now, so the bottom line behind this case here, and this is the Jacobo case, is that a casual or partial search is not diligent enough under the rule. According to this case, Second Circuit case, there's got to be some diligence shown, and again, just a partial, type search does not suffice. So let's talk a little bit about what happened here in this case. Again, this is a nice example of that we may be able to use in certain cases. So here, what happened is that the jury convicted the defendant of conspiring to engage in unlawfully in the business of dealing in firearms. Now, at trial, the government's proof that the defendant was not licensed to deal in firearms consisted of two documents prepared by the Bureau of Alcohol, Tobacco, and Firearms, the ATF. And one document was a statement signed by the ATF Regional Regulatory Administrator. They love those kind of names, describing an individual as custodian of ATF licensing records for several states. And the second document was a certificate from that individual saying that after a diligent search of ATF records, that no firearms license came in the name of that defendant. And again, as I said before, this is one of the typical things that the government uses this rule for, to show such things as failure to obtain a firearm license and that kind of thing. So the district court allowed that evidence in. It came in, and to no one's surprise, after that evidence came in, the defendant ends up getting convicted. Now, on appeal, the defendant argues that the certificate was inadmissible under the rule. And here, the Second Circuit gives us some great language. And the circuit says that the diligence requirement in the rule is one of substance, not form, and that it is, quote, not satisfied by a mere ritual incantation that the certificate results from a diligent search. The circuit concluded that if the circumstances indicate a lack of trustworthiness, the evidence should obviously be excluded, and the result of a less than diligent search is not admissible under this rule. What happened here is that the search was conducted using a misspelled version of the defendant's first and last name. They did searches, but a number of the searches that they did, again, were misspelled ways of spelling the defendant's true name. And the circuit again concluded that a casual or partial and ineffective search cannot justify the conclusion that there was no record, and that the mere fact that the custodian says that, that they engaged in a diligent search is not enough. And in this case, because this was material to the conviction, the court vacated the conviction and remanded the case. Really nice case if you have a similar situation. And this happens, we oftentimes, well, when is that going to happen to us? Well, it actually happens more often than what we think. So keep that in mind. Now, another one, and I'm not going to spend too much time on this one because we did discuss judgments of convictions at that was at the second series in this one. The second week when we were talking about character impeachment or impeachment through character. We're talking about prior convictions. We discussed this rule, but just to go ahead and review it pretty quickly, I'll give you a quick example as well. A judgment of a prior conviction can be is an exception to the hearsay rule. That is assuming that you have a trial or guilty plea, not a nolo. Nolo is not going to go ahead and do it. In addition, it's got to be by an offense that is punishable by a year or more, not a misdemeanor. But it is, if the requirements, prior requirements are met, it can be come in to prove a fact essential for judgment. As we discussed in the second session in this series, it can come in to show that an appeal is pending. The fact that there's an appeal pending doesn't mean that the judgment of conviction doesn't come in, but it allows us to go ahead and bring it in if we want to use to say if the government brings in the conviction and we want to show that it's an appeal for whatever reason we want to show that, then the rule allows us to do it. The critical thing is that the rule does not permit nolos, misdemeanors, and that sort of thing. I'm not going to go ahead and spend too much time on this following case, but for completeness sake, let's talk briefly about it. Here, the jury convicted the defendant of being a felon in possession. Prior to trial, the government had notified the defendant that it planned to use a prior conviction for being a felon in possession of a firearm as 404B evidence. The defendant moved in limine to exclude it because the conviction had resulted from a nolo plea. The district court denied the motion in limine, admitted the defendant's conviction. The defendant, once again, unsurprisingly, gets convicted after that very damaging comes in. That very damaging evidence comes in. In an appeal, the defendant argues that because the conviction was based on a nolo plea, the conviction did not constitute proof sufficient to allow the jury to find that, in fact, he had possessed prior ammunition and that sort of thing. The 11th Circuit agrees. The 11th Circuit agrees that in this case, while, say, a guilty plea is an admission of all the elements of the prior crime, a nolo is not. Instead, a nolo contendere plea is merely a, quote, consent by the defendant that he may be punished as if he were guilty and a prayer for leniency. That's what the 11th Circuit concludes. The 11th Circuit says the admission of the evidence of the nolo plea was impermissible and concludes that the district court erred. Okay, so let's go ahead and then here move into the hearsay exceptions that require unavailability. So for this one, say if the government wants an exception or a declarant statement, a hearsay declarant statement to come in, but it falls under one of these rules, the government has to go ahead and show unavailability. Now, let's talk a little bit about unavailability. And unavailability can be caused for a number of different reasons. It can be that the individual is absent and the proponent of the evidence cannot procure that witness's attendance, or it can be that the witness invokes the privilege, or it can be that the witness refuses to testify despite a court order. There's got to be a court order, however, or the witness has an outright lack of memory, or because of forfeiture by wrongdoing. That is, the defendants say the defendant participated in ensuring that that declarant is not a witness for whatever reason by making them disappear, perhaps by killing them, but only if the defendant intended to prevent their testimony. So if the defendant intended to kill the person, and that's it, but not intended to kill the person so that person could not testify, then the forfeiture by wrongdoing exception does not come in. Let's talk a little bit about that, and that's the Giles case. The Giles case is in the Sixth Amendment content or context, but nonetheless, it's an important case to talk about as it really hashes out this doctrine of forfeiture by wrongdoing. So what happened in this case, this is a Supreme Court case, a US Supreme Court case from 2008. What happened is that the defendant shot and killed his girlfriend, and at a trial, the defendant testified that he acted in self-defense. The government, in response to the claim by the defendant, sought to introduce statements that the defendant's girlfriend made to a police officer weeks prior to being killed. Okay, and as far as those statements basically were that the officer was responding to a domestic violence situation, and the defendant's girlfriend, who was crying, told the officer that the defendant had choked her, punched her, and threatened to kill her if he found her cheating on him. Now, the government argued that those statements should come in because the defendant had waived his right essentially to object because the defendant had engaged in forfeiture by wrongdoing. He had killed the girlfriend. The girlfriend was shot and killed, and certainly could not testify. So the government is claiming forfeiture by wrongdoing. Now, of course, the matter ends up making it to the Supreme Court, and the Supreme Court holds that a defendant forfeits his right to confront a witness if the witness is unavailable because of the defendant's wrongful conduct. So the defendant shot and killed the girlfriend. So far, that part is correct. But the Supreme Court makes it very clear that a second requirement is that the defendant must have also intended to kill her to prevent that witness from testifying. And there was no evidence in this case about that part here. In this case, the state court did not consider the defendant's intent, so the Supreme Court ended up remanding the case. Now, I mentioned that simply because, again, frequently the government and the courts, judges, get the doctrine of forfeiture by wrongdoing wrong. They get it incorrectly. The defendant, again, has to not only have ensured the disappearance of the person by killing them, threatening them, whatever, but also the defendant must have intended that disappearance to prevent testimony. Okay, now let's go ahead then, and we talked about the doctrine of forfeiture by wrongdoing. Now let's go ahead and talk about, let's go ahead and give an example of our rule. Let's go back to our rule here. Again, we're talking about these are exceptions that require unavailability. And allow me 1 second here. Let's talk about some examples here in this context. Allow me 1 second here. So these are situations where now it's the government that is trying to say that these exceptions apply because the declarant is unavailable. Okay, and oftentimes the government says, oh, now this exception here, one of the exceptions are, we haven't started looking at the exceptions. The exceptions are going to be such things as a statement against interest, dying declarations. We'll talk about them in just a moment. But first, the government has to establish that there's unavailability. And the government will often go ahead and claim unavailability. Now, let's look again at this case here, Tirado versus Tirado, and you'll see what I'm talking about. So here, the defendant was convicted of inducing an alien to enter the United States. This alien, I'll mention his name simply because it's easier for us to track how the facts played out by knowing the name. His name is Giles Ramirez. So the defendant supposedly was responsible for illegally bringing this alien into the United States with knowledge and reckless disregard of the fact that the entry was illegal. Now, so prior to being released and returned to Mexico, this fellow, Giles Ramirez, the fellow that supposedly the defendant brought into the United States illegally, Giles Ramirez, the government took a deposition of Giles Ramirez. This is the witness, the individual that supposedly was brought illegally into the United States by the defendant. So the defendant, the government takes this deposition, and in the deposition, the individual, Giles Ramirez, talks about how the defendant, facilitated his entry here, that the defendant knew about him being illegal, that the defendant, despite all that, brought him in, etc. So the government takes this deposition before Giles Ramirez is released and sent back to Mexico. And the government tells him that they will be in touch with him prior to trial, and that for trial, they will bring him back to the United States and have him testify at trial. Well, 8 days prior to trial, the customs officer assigned to the case sends a letter to Giles Ramirez telling him of the trial date and the location, expecting that Giles Ramirez is going to show up. Oh yeah, here I am, and at trial. Now that you deported me, I'm back and to testify against the defendant. This officer also speaks to Giles Ramirez's brother, who informs the officer that Giles Ramirez didn't have a phone, but that he, the brother, would try to go ahead and talk to the brother and tell him, relay the message from the officer that the trial was going to take place on whatever day at whatever place. So again, this is an officer in the United States calling this individual in Mexico saying, hey, we need you here in the United States for this trial. They can't get a hold of the guy. They send him a letter. They then try to call his brother, etc. So the government just makes a very shoddy effort at trying to secure this individual. Of course, the guy didn't show up, the Giles Ramirez didn't show up at trial. And, but the government, so he's unavailable. Unavailable can show he's unavailable, and they sell it to the district court. The district court concludes that he's unavailable under the rule, and the deposition comes in. Now, And right now he's talking about the unavailability part. We're actually not talking about the exception. We'll talk about the exception in a minute. But before we talk about that, we need to talk about issues dealing with unavailability. And we talk about one in the Giles case. Now we're talking about the government trying to bring the stuff in.
Rene, may I interrupt for one moment, please, and ask a question from our audience about unavailability? And we have a question, which is, can the government claim unavailability if they refuse to grant immunity to a witness for that witness's testimony?
That's a really good question. That's, in fact, an excellent question. In fact, if the person asking can send me an email, I'll send you a number of cases dealing with that. I'll send it to you by the end of the week. The answer to that is that, it depends, but that, the government's going to have to go ahead and try to make some effort to do it. But again, I'll be more than happy to send you cases. I got cases that can go ahead and help you with that issue. And unfortunately, I don't have them here with me, but I will be more than happy to go ahead and provide them with you. I should have talked about that very issue. Should I have had a case on that? Certainly the next time that I speak on this, I will have an example on this very issue because that's a very good question. But do please, send me your email so I can go ahead and send you some case law on that issue. Going back here to this case, so the Fifth Circuit here notes that the defendant here argues that the district court erred in finding that Garay Ramirez was unavailable. And the Fifth Circuit noted that the measures taken by the government did not constitute good faith or reasonable efforts at doing that. And the government has to engage in good faith efforts and reasonable efforts to do that, to try to secure the witness. And certainly the argument being, including, if necessary, to grant immunity, as that very excellent question alluded to. Now, here the government failed to make any concrete arrangements with the witness prior to his deportation and delayed trying to get a hold of the witness prior to trial, waited till 8 days before, and that the way that the government tried to do it again was shoddy and spotty and didn't amount to really anything. So as a result, Garay Ramirez was not unavailable under the rule, under 804A, and the district court erred in admitting his videotape deposition. Because the error was not harmless in this case, the Fifth Circuit vacated and the defendant's conviction and remanded for a new trial. Nice case that deals with the efforts that the government has to go ahead and take to demonstrate unavailability. Now, let's talk about this other case here. This is also another nice case that fleshes out the issue of unavailability. What happened here is that this is a Hopsack case, and a jury convicted both the defendant of conspiracy to extort money in violation, convicted the defendant of conspiracy to extort money in violation of the Hopsack. Sorry about that. Now, here what happened is that the defendants who owned a repair company, the allegations were that they used threats, fear, and violence in order to extort money from owners of transport companies. Now, one of the owners of the transport company was working with the FBI and agreed to tape a meeting with the defendants. Now, the trial court judge ruled that the transport company owner was entitled to invoke this Fifth Amendment privilege against self-incrimination. The owner of the company did not want to testify, and he said so. He didn't want to testify. He didn't want to get involved, etc. So, so what happened here is that the trial judge concluded at the government's behest that the owner of the company was unavailable because the owner of the company had said that he didn't want to get involved, he didn't want to testify and all that. So the court, at the behest of the government, ended up allowing statements of this business owner, the one that didn't want to testify. And the government ended up introducing 5 tape-recorded conversations between the transport company owners and the defendants. Now, on appeal, the Second Circuit noted that the district court erred in finding that the transport company's owner was unavailable to testify because the district court did not order him to testify. Instead, the district court simply relied on the representations of the government that, that he didn't want to testify, that he didn't want to get involved, that he refused to testify, and that was it. According to the Second Circuit, the trial court needs to go ahead and follow procedure here, order the individual to testify, and if the individual refuses, then there really cannot be a finding of unavailability. And in this case, the Second Circuit ended up finding that the issue was such that the magnitude of the error was such that it required a reversal and of the conviction and a remand for a new trial. We talked about unavailability there for a few minutes. Now let's get into the actual exceptions under this rule. And one of them is your classic dying declaration. I'm going to be covering 2. There's 5, but I'm just going to cover 2. Again, each one of these things could be the subject of an hour presentation. So I'm having to, by force, having to go ahead and limit the scope of what I cover. And my sincerest apologies for that. But here you go, dying declaration. The dying declaration is an exception in criminal cases. It's got to be a homicide case, and it's got to be made while the declarant believes death is imminent and concerning the cause of death. So in a criminal case, it's got to be a homicide case. The declaration has to go ahead and be while the declarant believes death is imminent and concerning cause of death. This is what, the law school professors, at least when I went to law school, my law school professor used to say that it's got to be under the beatings, the flappings of the angel of death. So the declarant has to be hearing the flappings of the angel of death for this to apply, for this exception to apply, dying declaration. Now, as you may remember from law school, the Demarcy case here is the old Supreme Court case of Shepard versus United States. And what happened, Shepard is another great case, just like the Hillman case that I talked about earlier. But what happened in Hillman, in Shepard, is that a jury convicted the defendant of murdering his wife by poisoning her. The defendant was a doctor, and allegedly he put poison in her drink. Now, what the government here introduced evidence that while the defendant's wife was sick in bed, she had told the nurse that she drank alcohol before she collapsed, and that the defendant had put poison in that alcohol, and that the defendant was trying to poison her. Now, that statement came in a trial and came in as a dying declaration. The district court admitted the statement as a dying declaration. Now, of course, the matter ended up making it to the Supreme Court, and it became, this marquee case, Shepard versus United States. And on appeal, the Supreme Court noted that in order for the statement to be admissible as a dying declaration, the defendant's wife must have spoken the statement, quote, without hope of recovery and in the shadow of impending death. Very poetic language. Supreme Court noted that in this case, that was not what had happened. In fact, the defendant's wife did not make the statement without hope of recovery and in the shadow of impending death. In fact, on that very day, on the day of the conversation, she did end up dying, but on the day of the conversation, her physicians thought that she had greatly improved and that she was on the road to recovery and that she felt that she was recovering. She has spoken with her physicians and it seemed actually like this day was a day where everybody thought that she was improving. So, the statement was not made under the shadow of impending death, and consequently, they did not, meet the exception. Of course, in the time of this case, the federal rules of evidence certainly did not exist, but nonetheless, the exception existed as a long-held exception under the common rule, the common law. The other exception that I want to talk about when it comes to issues dealing with unavailability is statements against interest. Now, so for it to come in, again, first of all, we got to talk about unavailability. The party trying to present the statement has to establish unavailability. We talked about unavailability a few minutes ago. And the statement has to be one against interest. It's got to be either contrary to the declarant's pecuniary or proprietary interest, and or it's got to be one that subjects the declarant to civil or criminal liability. Now, if the declarant is inculpated, the declarant is inculpated, but it's offered to exculpate the accused, there needs to be corroborating circumstances clearly indicative of trustworthiness. Of course, the rules distrust our clients, and consequently, you have that. But we'll see a good example of how of a case where we can meet that requirement, or where the case met that requirement. So let's talk about this a little bit more by talking about some potential scenarios here. So let's talk about an example. After a car accident, the passenger of the car says to the police, oh my, let's say that it's a fatality. Oh my gosh, we should have had our lights on. Is that statement going to qualify under statement against interest or not? And of course, it depends. It depends upon on who was the declarant that made the statement. Now, the hypo here tells us that it's the passenger. Well, what about the passenger? Again, it depends upon who the passenger is. If the passenger is, say, my friend, I'm the driver, I own the car, and it's my friend. My friend comes out and says to the police, oh my gosh, Rene should have had his lights on, and we hit this car, the other car is total and all that. Obviously my pecuniary proprietary interests are at stake. I can be sued for damaging the other car, perhaps even injuring somebody and that sort of thing. But, what's my friend losing out of it? Nothing, right? But let's say, for instance, it's the driver's or owner of the car, their spouse. Then in that case, things are different. Then, of course, their pecuniary or proprietary interest may suffer. So in this case, it very much depends upon who the declarant, is. Now, before I, give you some examples of cases of defense favorable cases dealing with this rule, let's go ahead and draw some comparisons, because oftentimes party admissions are confused with statements against interest. My law students oftentimes confuse them. They're two very, very different things. Party admissions, are coming under exclusions, as we discussed last presentations. They are hearsay exclusions, and they have to be made by the party against whom they're being used. They do not have to be against interest when made, and the declarant can be available, obviously. Statement against interest can be made by anyone, whether it is a party or not a party. They can be made by anyone, but they have to be made against interest when made, whether that interest is pecuniary, proprietary, subjecting the individual to civil or criminal liability, you name it. But again, it's gotta go ahead and be against the declarant's interest when made. And the declarant has to be unavailable. So this is, a handy little, outline of the differences between both. Now let's go ahead and talk about some cases that illustrate the application of this rule. There's a great cases here that you can use, that we all can go ahead and use for our benefit. So the first one is Lily. Lily, and what happened in Lily is that the jury convicted the defendant of forging an endorsement on a check drawn on the United States Treasury. Now, here, the defendant's husband was also charged, but the defendant's husband pled guilty. And he is more than happy to plead guilty and have his wife be thrown under the bus. Now here, an agent testifies about this statements that the husband made to him. The husband ended up being unavailable because of privilege. Now on appeal, the defendant argued that the district court erred in admitting the husband's statements that the husband had made to the agent incriminated the wife. Were statements that certainly incriminated himself, the husband, but certainly incriminated the wife and were hurtful to the wife's case. The Eighth Circuit here said that while the husband's statements did incriminate him and in a sense were against interest, that was only the case in part. They were only partially against interest. And while the husband admitted to wrongdoing in this statement to the agent, for the most part, the statement was inculpatory of the wife and not of him. So the statement inculpated the wife, inculpated him in a sense, but in a sense also tried to minimize his involvement. So the Eighth Circuit noted that that to be consistent with the rule, with 804B3, all portions of the husband's statement that were not against interest should have been excluded. All portions that were not against interest ought to have been excluded. Because of the error, the circuit went ahead and reversed and remanded. Okay, let's go ahead and go to the next case here as we are wrapping up here. And thank you so much for being with me. I really appreciate you being with me this afternoon. This is Ocasio-Ortiz, and this is a really good case because it's us, the defense, trying to go ahead and show a statement. I'm going to have to take you all the way because I want to make sure that we're all on the same page here. 804B3, statement against interest. Here, the defense is trying to show a statement against interest to exculpate the defendant. And again, in that case, if the declarant inculpated but offered to exculpate the accused, need corroborating circumstances. So let's see how things played out here. This is a good case and the effort of good lawyering. The defendant was convicted of numerous crimes arising out of carjacking and murder. This occurred in Puerto Rico. At trial, the government's evidence rested on the testimony of a cooperating witness, but testified that he, the defendant, and 4 other co-conspirators carjacked the victim, and that he heard one gunshot after the defendant asked another co-defendant for a gun. Now, that co-defendant had died prior to trial, and the defendant attempted to introduce evidence from the co-defendant's mother that shortly before the co-defendant's death, he had confessed to her that he alone had killed the victim, not the defendant. So this is the co-defendant confessed to his mom before he died that he had shot the victim, he alone, not the defendant, okay? The defendant is trying to get this in at trial. Of course, the government, objects up and down, they cannot come in, and the district court, precludes the testimony under Rule 804B3 because there's no corroborating circumstances. An appeal, the defendant argues that the district court committed reversible error by excluding this testimony. The First Circuit agrees, and the circuit notes that 804B3 is founded on the common sense notion that reasonable people, even reasonable people who are not specially honest, tend not to make self-inculpatory statements unless they believe them to be true. Corroboration is required to prevent fabrication, such as the First Circuit. But this First Circuit notes that here there were corroborating circumstances because telling a close family relation, in this case, the mother, that in this case, the declarant telling his mother, that consisted of corroborating circumstances. You're not going to go and tell your mom, oh yeah, I killed this guy and I'm the only one that killed him. It wasn't the defendant. You're not going to go ahead and say that unless, there's some reason for that. So the Eighth Circuit here noted there were corroborating circumstances. The fact that he told his mom, that was corroborating circumstance, and that the evidence ought to have come in. And in this case, obviously, that very important evidence being kept out, that error was not harmless. So the court went ahead and vacated the conviction and remanded the case. Now, as we are getting close to time, let me go ahead and just briefly mention Federal Rule of Evidence 806. I discussed that the last time. 806 is a very important tool for us, and that is that it allows us to go ahead and attack or support a declarant's credibility, and a hearsay declarant's credibility, as if the person was on the stand. The government brings in hearsay through some exception or whatever. We have the right to attack that individual's character for truthfulness, the hearsay declarant, even if they're not there. We have the right to go ahead and attack their their character for truthfulness. We have the right to go ahead and impeach them as if they're on the stand by bringing up a prior conviction, etc. A very important, certainly a very important rule that can be critical for us in the right case. Now, this is illustrated in the Moody case. I'm going to go ahead and talk very briefly about Moody as we're coming to time. But here in Moody, the defendant is convicted of fraud. The government argues that the defendant, who served as a trustee in a philanthropic foundation, siphoned a lot of the money. The government in the case used extensive hearsay of non-testifying declarants to admit highly incriminating remarks about the defendant. And then the defendant attempted to go ahead and attack their credibility. The credibility of this individuals, this non-testifying hearsay declarants. The court did not allow the defendant to go ahead and do it. And the Fifth Circuit concludes that there's error under the rule, under 806. The Fifth Circuit notes that 806 permits the defendant to elicit opinion testimony from the in-court witnesses about the declarants, the hearsay declarants on truthfulness, even if they are not testifying. Even if this is, again, a hearsay declarant, the hearsay came in through some exception, the person doesn't even have to have been a witness, and still we have the right to go ahead and challenge their credibility because of that error. The Fifth Circuit reverses the conviction and remands the case. Now, so we go back to our hearsay outline. We discussed so far in the last session whether something is indeed a statement. If it is a statement, is it an offer for its truth? Does it fall under an exclusion? Today, of course, we talked about exceptions, and certainly I had to limit our discussion to what I think are the critical ones, and forgive me for not talking about others that you may think are perhaps even more important than the ones that I raised, but I think that you would agree that the ones that I raised are certainly important. The last piece of the puzzle, of course, is the Confrontation Clause, and certainly that we don't have time to go into that here as we're running out of time, and that is most definitely the subject of another presentation. But then once we conclude with that, we still need to look at whether the statement is hearsay. You can have something, for instance, like an excited utterance that still may violate the Confrontation Clause under Crawford. And then, of course, we need to go ahead and do the Crawford analysis. That is, is a statement being offered for its truth? If it's not, then you don't have a Crawford issue. Is a statement a violation of the Confrontation Clause? To figure that out, we need to determine if the statement is testimonial. To determine whether the statement is testimonial, we look at what is the primary purpose of the statement, amongst other things. Is it to establish or prove past events potentially relevant to criminal prosecution? And a critical thing for us to remember before we close is that a hearsay objection will not preserve a Confrontation Clause challenge. So be sure to go ahead and make the Confrontation Clause challenge also in addition to your hearsay challenge. Well, I cannot thank you enough to each one of you for being here today. For those of you that saw me on prior occasions, thank you so much for coming again. I can't thank Vanessa enough for inviting me, and the good folks at NACTO for having me. And like in the Lizzie Borden case, I wish you many not guilties, and thanks for everything that you do. We are truly the guardians of liberty. And best of luck to you. Should you need anything in Las Vegas, don't hesitate to let me know. And if you ever want to talk about a hearsay issue, please just reach out. So thank you very much. And thanks to you, Vanessa.
Thank you very, very much, Rene. We truly appreciate it.